Good morning. Now I am going to present a topic on Companies Act 2013 about its sections, schedules, chapters and more details about the Companies Act. First of all, the Companies Act is formulated with the objective of, that is the Companies Act has been enacted uh, with the objective of consolidate and amend the law relating to the companies and certain other associations. The said act has been in force for about 57 years and has been amended for several times. In view of the changes in the national and international economic environment and expansion and growth of economy of India, the central government, after due deliberations, decided to repeal the Companies Act 1956 and enact a new legislation to provide for new provisions to meet the changed national and international economic environment and further accelerate the expansion and growth of our economy. For this purpose, a bill, namely the Companies Bill 2009, was introduced on 3rd August 2009 in the Lok Sabha, along with the statement of objects and reasons appended to the said bill, outlining its salient features. The said bill was referred to the Parliamentary Standing Committee on Finance for explanation, examination and report, and the committee gave its report on 31st August 2010. And subsequent to the introduction of the Companies Bill 2009 in the Lok Sabha, the central government received several suggestions for amendment in the said bill. The Parliamentary Standing Committee on Finance also made numerous recommendations in the report. The central government accepted to general the recommendations of the Standing Committee and also considered the suggestions received by it from various stakeholders. In view of the large amendments to the Companies Bill 2009 arising out of the recommendations of the Parliamentary Standing Committee on Finance and suggestions of the stakeholders, the central government decided to withdraw the Companies Bill 2009 and introduced a fresh bill incorporating therein recommendations of the Standing Committee and suggestions of the stakeholders. About the Act 2000, main features of, we can say that the Companies Bill 2012 was introduced and passed in Lok Sabha on 18th December 2012 and by Rajya Sabha on 8th August 2013 and asserted by the President of India on 29th August 2013 and notification came out on 30th August 2013. The Act seeks to receive the following objectives: to achieve transparency, accountability and high standard of corporate governance or management, to enforce stricter actions against fraud and gross non-compliance with latest company law provisions, to set up institutional structures in the form of various authorities, bodies and panels, as well as recognitions of various roles for professional and other experts, to implement more effective and time-bound approvals and compliance requirements, to recognize the various new concepts and procedures that protect the interest of all stakeholders, that is, shareholders, debenture holders, company professionals, creditors, financial institutions, bankers, tax authorities, management personnel, etc. Major corporate frauds occurred in recent times in India. The major reasons for such incidents were mismanagement, non-compliance, and gross neglect of legal requirements. The Companies Act 2013 has made an effort to provide suitable mechanisms to guard against such incidents in the corporate sector. The salient features of the Act are: the Companies Act was notified on 30th August 2013. It contains 470 sections and 7 schedules. It consists of 23 chapters. Act extends to the whole of India. And the provisions of the Act applies to companies incorporated under the Act or under any previous company law, insurance companies, banking companies, companies engaged in the generation and supply of electricity, except in so far as the said provisions are inconsistent with the provisions of the Electricity Act, and other company governed by any special act and any body corporate as the central government may specify in this behalf. So these are the details about the Companies Act 2013. That is, it contains 470 sections and 7 schedules. There are 23 chapters, and most probably The act extends to the whole of India. It is applicable to the India as a whole. So these are the salient features of the Companies Act 2013. Okay, thank you. Good morning. Today I'm going to present a topic on the characteristics of a company. Company characteristics can be divided, can be broadly said as incorporated association, legal personality, perpetual succession, limited liability, transferability of shares, common seal, separate property, and separation of ownership and management. We can look into one by one. First one is incorporated association. It means a company is registered body of persons and every company comes into existence by incorporation under Companies Act. Registration is absolutely necessary for the formation of a company. And the second one is legal personality. Legal personality means a company is an artificial person created by law. It is a legal person in the eyes of law and it is different from persons who form it. Suppose seven persons join together in the that is the minimum number of persons who are formed for a company is seven, and and form a company. Then there is an eighth person also, that is the company. It is like a natural person but has no physical existence. It exists only in the eyes of law. And third point is perpetual succession. It is a company has a perpetual succession or continuous existence. Once the company is registered, it will go forever. The change in membership does not affect the existence of the company. Members may come and members may go, but the company will exist there itself. It is a creation of law and only through legal proceedings it can be terminated. Fourth one is limited liability. That is, the members of a company have limited liability. It means that the liability of the members is limited to the extent of the par value of shares taken by them. If already paid the par value of shares, then there are more liability. Whatever may be the liability incurred by the company, thus the private assets of the members are not liable for discharging the debts of the company, and the creditors of the company cannot sue the members for recovering the money lent by the company. Next one is transferability of shares. That is, in the case of public company, the shares are freely transferable. The consent of the company is not required for the transfer of shares by any members. No shareholders is permanently attached to the company, and so in the case of private company, the articles restrict free transferability of shares by the members. And next one is common seal. That is, since a company has no physical existence, its activities are discharged through the directors and officers. They are the agents of the company, and the common seal with the name and registered office address of the company engraved as on it is used as the authentication for all important documents and contracts executed by the company. Next one is separate property. That is, a company being an artificial legal person can sue a property in its own name. Similarly, it can contract liability in its own name. The assets of the company belong to the company alone, and the shareholders cannot raise any proprietary right to these assets. And next one is capacity to sue and be sued. That is, a company can file suit against third parties for enforcing its rights. Similarly, a third party can file suit against the company for breach of any legal duties binding on it. Next one is a separation of ownership and management. That is, unlike a proprietary concerns, there is a separation of ownership and management in the case of a company. That is, the shareholders are the owners of the company, but the management is vested with the board of directors. The board of directors, who are the representatives of the shareholders, manage the day-to-day affairs of the company. These are the main characteristics of a company. Let us check one by one again. Incorporated association, that is, a company should be registered. Legal personality, company is an artificial person created by law. Then perpetual succession means company has a continuous existence, that is, members may come and go, but the company should remain as though it is. Limited liability, the liability of the members is limited to the extent of shares held by them. Transferability of shares. There are two types of companies, public company and private company. And in the case of public company, shares are freely transferable, but in private company, shares are not freely transferable. Next one is common seal. That is, unlike company, as it is an artificial person, it has no physical existence. All the documents are registered and the address of the company are engraved using the common seal. Separate property. The property of the company is not the assets of the owner. So the owner cannot take any property from the company. Separation of ownership and management. Management and ownership is separated. Both are different. Owners are shareholders and management is board of directors held by the from the shareholders, selected from the shareholders. These are all the characteristics of a company. Thank you.